Well, good afternoon, everybody, and welcome to this afternoon's free webinar today on tenancy mediation. This is one of our online showcases presentations, all about disputes between tenants and landlords, landladies, around issues to do with rented properties, lease agreements, tenancy agreements, and breaches thereof. So, just before we tell you all about that, may I introduce myself? I'm Dr. Mike Talbot. I'm the CEO and founder of UK Mediation. Started this 23 years ago with a background in psychotherapy. So just to mention that as a reference point. So as UK Mediation, we are into the psychology of conflict. We're not from an HR background, from a tenancy law background, from any other background than people who are curious about what goes on in conflict, what goes wrong when we fall out with each other, why it's so difficult to move on from conflict, and what we need from an impartial third party in order to help resolve our conflicts. So that's our sort of angle. That will be the flavour of the webinar and of all of our other webinars. So this is where we're starting with this kind of an aspect, this kind of a take on what goes on with regard to tenancy mediation. So overview of what we're going to do today is, first of all, look at tenancy mediation in action. So I'm going to take you through, for the majority of the 45 minutes or so that I've got with you this afternoon, the process involved in a tenancy mediation. So we'll see a dramatised build-up to a fallout between a tenant and a landlady, and then we'll see how the mediator responds to that with some individual meetings and a joint session, so that the two parties, the two sides in this dispute, can try and get their heads together and work out what's going on between them. So that's the in-action bit, and that's a large part of it, within which we'll look at the 7-stage mediation model, break that down step by step, and also how it applies in this case to a tenancy dispute. So those of you who are familiar with our webinars, you may have seen before this kind of a model in action with neighbourhood disputes, workplace disputes, commercial disputes, disputes within families. This is how it applies to a tenancy dispute in particular. So I hope you find that interesting and enlightening, especially because we're doing it in this showcase fashion, so you can actually see the dramatised action, as it were. So first of all, tenancy mediation in action. Let's meet Molly and Helen, our two characters. Let's get straight in there and look at what's going on between these two guys. So the setup is that Molly is a tenant in a house on her own. She's got 2 kids, no other tenants in there. It's not multiple occupancy or anything like that. And there are some issues with the property from Molly's point of view. And we'll see in the drama that there are also some issues with Molly's conduct within the property from the landlady's point of view as well. So let's take a look first at a sort of setup to what goes wrong between these two guys and the conflict with a piece of video.
Molly is a single parent of 2 small children. She rents her house through a letting agent from Helen, a private property owner. Molly has been having some issues with the condition of the house and with things not working properly or being repaired in good time. Helen in turn has concerns about how Molly is using the house. Molly is becoming increasingly impatient with what she sees as Helen avoiding her and fobbing her off, and has just decided to stop paying her rent until things get sorted out. Helen is very unhappy about this, as she considers that she has done everything she can to meet her obligations to Molly. Molly is telling her friend about what has been going on, and is about to call Helen again to complain about what she sees as a lack of action around her concerns.
Yeah, well, I just dropped the kids back off at Mum's. Yeah. Oh no, yeah, I'm really looking forward to it too. I need to let off some steam after all of this house crap. Yeah, well, the window's still not been fixed, the security light's still not been done, and then the mould, she's saying that that's not even her problem, so I don't know how to begin to deal with that. Yeah. Oh, for God's sake, the water's not even hot. No, the engineer was supposed to be out yesterday and he hasn't even fixed it. No, I know, it's ridiculous. I'm really losing my patience with her. Yeah. Well, you know what? I'm just going to call her now. Yep. Okay, bye.
So this is the sitting room. As you can see, lovely big spacious room, great big bay window overlooking the town, lovely view. Furniture's included. Oh, excuse me just a second.
Okay, no worries.
I just need to take this. Hello, Helen Thompson. Hi, Molly. Yeah, I'm just with a client at the moment. It's a bit awkward. I'm just showing someone around a house. Okay. Okay, Molly, can you phone the letting agency? We've talked about this before. You need to phone the letting agency with all the maintenance issues. I really can't talk at the moment, okay? Okay, you need to phone Whitford's. Okay, bye. Sorry about that. Okay, any questions?
No.
Okay, let's go through to the kitchen.
Helen has also started getting calls from Molly's neighbours about what is going on in and around the house.
Hello, Helen Thompson. Hi, Simon. No, good to hear from you. Yeah. Okay. Okay. Yeah, I'm sorry. No, I know you don't like to complain. Yeah. Well, how many of them? What time? Oh, God. Okay. No, she is allowed to smoke in the garden, but not in the house. Oh, God, do you think? Okay. No, I'll have a word with her. No, it's fine. Leave it with me. Okay. Okay, sorry, Simon. Okay, speak to you soon. Bye-bye.
Helen makes an inspection visit.
Oh, God, what a mess. So, Molly, Whitfords have been in touch this month to say you haven't paid the rent, is that right?
Yeah, that's right.
Can I ask why, please?
Because you're not providing on your half of the contract.
How do you get to that?
Because we have a window seal that's been broken since I moved in, so the window won't shut. We have mould in the bedrooms, and we don't have any hot water. The boiler is completely broken.
Molly, number one, the window is broken because your daughter broke it. Number two, there's mould in the bedrooms because you insist on drying your laundry inside, even though it states clearly in the contract that that will make condensation, which will create mould. And number three, I've sent someone round to fix the boiler, and when he called round yesterday, nobody answered the door.
The window was not broken by my daughter. We have photographic evidence of that on the day of moving in. I have been in the house this whole time period when you've said that the engineer is going to be coming, and he did not appear whatsoever.
Okay, let's just park that for a second, because I've had a phone call from Simon next door, who is also not happy with how things are going in the house. He has said that he has been hearing late night parties in the garden, people coming and going at all hours, drug taking in the garden, fairly sure that the smoking that's happening in the garden is not regular tobacco, because I have seen the evidence, Molly, in your bedroom.
And why the fuck have you been in my bedroom?
Because it's
Listen,
my house.
It's my house
no.
while I'm in here.
No.
And I did not give consent for you to be in there. I am not happy with this. Now you can get out of my house.
Molly, you're
get
not...
out of my house.
Fine,
I am not giving you any money.
You will have a letter from my solicitor by the end
Get out of my house. Get
the week.
out. Get out.
Fine.
So a bit of drama there with Molly and Helen in the house, and you can see just how quickly things go wrong, how quickly they escalate. So I guess the question would be for us at this stage, what's going on really with Molly and Helen? What's gone wrong between them? Most tenancy agreements work very well. Most tenants are happy. Most housing providers, landlords, landladies are quite happy. So what's going wrong here? What it looks like is going on, first of all, is that both are claiming breaches of the tenancy agreement. So from Helen's point of view, Molly's having parties, she's misusing drugs allegedly, she's in breach of the tenancy around noise and smoking and those kinds of things, and not paying the rent as well. Whereas from Helen's point of view, from Molly's point of view, the house isn't up to scratch, hot water's not right, there's a problem with a window seal and so on and so forth. So the tenant's alleging that the property isn't up to scratch. The landlady is alleging that the tenant's not meeting her obligations. So allegations from both sides really, and of course disagreements about who's responsible. So Helen's going to be alleging that the broken window seal is because of one of Molly's children and what they did, whereas Molly says it's the landlady's fault and she's got photographic evidence to prove it. Problem about the hot water. Landlady is saying that Molly wasn't there to let the engineer in, so he or she couldn't actually do the repairs that were required. Very, very typical kind of things that would come up in many a tenancy agreement. A couple of things that are not coming up here, which are also common, are to do with upkeep of common areas, provision of services, particularly in a multiple occupancy, or particularly in a block where there's need for maintenance of common areas, things to do with litter, rubbish, stairs, lifts, lighting, security, etc. So we haven't got any of that, but here they are both pointing the finger and each is saying it's your fault. And here we've got a bit of a complication, which is third-party reports of Molly's conduct. So one of Helen's other tenants, I think it's a tenant, is also calling up and saying, do you know what Molly's being up to? So this is a sort of an added weight to the dispute from the landlady's point of view. We could say, well, they could surely work it out, and most disputes don't become disputes because they are simply figured out in a conversation, in a dialogue. Two parties get their heads together and figure out what needs to happen in a negotiation. Well, that's fine, and if that was the case all the time, you wouldn't need mediators, so we'd be out of a job. But the problem is that things can just get through to this level of sort of mistrust and communication. It gets to the point where they don't trust each other and they've started shouting at each other, or in this case, Helen coming into the house really when she shouldn't really have done. She should have given her some notice, but from the point of view of Molly, she feels intruded upon by the landlady, who is not meeting her obligations anyway. So the communication's broken down, they don't trust each other. And what it sounds like from Molly's point of view is that she's just getting fobbed off by Helen. She keeps telling her about these things that need fixing and need fixing now, and Helen's not doing it. She feels like she's being fobbed off. From Helen's point of view, she's meeting her responsibilities, and because of this real breakdown in communication, they've got to the shouting stage. So they're no longer having a sensible dialogue where they're listening and responding, taking one another's interests into account, putting their heads together, trying to collaborate and come up with a solution for what needs to happen. So when it gets to this stage and there's all that mistrust and it's got to the yelling point, this is when there's a need for really some third-party intervention would help. We never overstate the need for mediators. There's quite a lot of disputes that come to us, so we think you don't need a mediator, you just need an opportunity to have a conversation. And sometimes what people need is the skills and confidence to walk towards these conversations. But if that's not there, or if we've gone past that point, if for any other reason the two parties are not communicating, rather than it hurtling off to court or solicitors get involved and letters start flying to and fro, perhaps there's an opportunity for an impartial third party to help these two guys to come together and have a proper conversation, in which case we would think about mediation. And here we go, bringing in a mediator. So let's launch straight in with this and think about the 7-stage mediation model. Those of you who've trained with us already would be familiar with this, and there's a fairly common sort of generic model that a lot of people use. This is our own variety, our own version of it. Again, paying attention from our point of view, in particular, to the psychology of conflict. Less about legal rights and wrongs, less about having an in-depth knowledge around tenancy law, and rather more to do with the individuals who are in conflict. And our approach is, if you can understand the individuals who are in conflict, you could understand what they would need in order to resolve their conflict. So that's how we come at these things. So first of all, 7-stage mediation model. Let's have a look at. What we do is have an initial contact with one of the parties. It doesn't matter who goes first. The purpose of the initial contact is to allow them to offload, to tell the story from their point of view. For us to, as mediators, to think about their interests, what are their underlying needs and imperatives and drivers, and get their agreement to take it forwards this way. That's really what we do. A lot of active listening involved, a lot of allowing the party to tell the mediator about their experience of the conflict. So we're not so bothered about dates, times, places, how many times you called the boiler guy, what time it was when the boiler guy came round and you weren't in to let him or her in. We're really more interested in the experience of the conflict from the two parties' points of view. So that's what happens in the initial stage, and we'll see again in the second stage where we turn it round and hear from the other party. But first of all, we're going to see what happens in stage 1, hearing from Molly. I'm just going to say a few things about private before I let you go and tell me everything that's been going on. All right.
Yeah.
So the in private thing, number one is anything you tell me in this room stays in the room. And as long as I have no concerns, this sort of conversation stays just between the two of us. I'm not going to feed things back to Helen. I'm not going to feed things back to the CAB, who've pointed you towards the mediation service, I understand. I'm not going to make any written record of what you say either. You might see me do a little bit of scribble, but that's just for my memory. I don't keep any notes. I'll shred those at the end of today. And I certainly don't write any report or anything like that.
Okay.
If at the conclusion of this whole thing, you and Helen decide that it's worth writing a few words down in the way of a summary or an action plan or an agreement, I can help the two of you to do that. But that's very much in your words, not mine. And I'll help you to get that written down, and you two decide if anybody else gets to see that as well. Okay, so that's the only thing that gets written down. I don't give you advice. I don't direct you or Helen into any actions or tell you what you've got to do or say who's right and wrong. That's not my business. My business is only to help the two of you, once I've heard from you both individually, to have a good conversation later and come up with your own understanding and agreement about how to make things better.
Okay.
All right.
Yeah.
I'm saying exactly the same thing to Helen, and I will also say to Helen that the only exceptions to everything I've said is if I have any concerns over anyone's safety. So if I'm concerned for your safety or Helen's safety or anybody else's safety, including your kids or even your neighbours or anyone else, I may have to make some disclosure and to make sure that people's safety is put to the top of the list, that it's paramount.
Okay.
All right, but apart from that, it's all private.
Okay.
Does that sound all right?
Yeah.
Now, sorry to burden you with a bit of paper, but everything I've said to you is written down so that I can be really clear that I'm saying the same thing to each of you. So just have a quick look at that for me, please, Molly. And if you're happy about that, and if there's any questions, do ask them, please, either now or later on. But otherwise, stick your name on that for me. Thank you very much. I'll put that away. It's the only formal thing I do, really. And it's your time to tell me about what goes on between you and Helen.
Okay. Where to start? Well, I moved in to the house with my 2 young kids,
Yeah.
I'd say about a year ago. And at the start, everything was sort of going as you'd sort of expect it to with the tenancy. We were finding a few issues, like the boiler. Issues with the boiler were sort of around at the very start. We had issues with windows. There'd previously been a mould problem, obviously, with the previous tenants or something, because it was there when we got there.
So it sounds like there's a few issues with the house that haven't been addressed. So tell me a bit more about that, Molly. Start with the boiler issue.
Right, well, we've had a lot of issues with the boiler. We have no hot water, like no hot water. So I've got stacks and stacks of pots in my kitchen. My kids haven't been properly bathed in ages because like we don't have anything to do that with. So yeah, like you would have thought that she'd think about this and go, yeah, boiler's not working. It's a single mum with kids. How is that going to affect her? But it seems as if she doesn't really give a shit at all, to be honest. She's probably got a perfectly working boiler in her house, so why would she care about us?
So there we're hearing from Molly as party one in this situation. So she's laying out her concerns about the property, concerns about the landlady's lack of responsiveness from Molly's point of view. And it would be very easy to get drawn into Molly's side of the story. So as mediators, what we're being very careful to do is to ensure that we stay impartial. So yes, we do need to give Molly a good chance to offload, to think about her interest, to think about getting her agreement to take it forwards this way into mediation. And as we get invested in Molly's interests and hear her perspective on what's going on, we've got to make sure we're not taking sides. So in a manner of speaking, what we do is take all sides. So we need to hear from Molly, get invested in her interests, and then hear from the landlady Helen, and get invested in her interests as well, so that when we come to have the joint dialogue in the joint session later on, that we feel we're giving them equal negotiating power, an equal chance to put their side of the story forwards, an equal chance to respond to one another and come up with some kind of consensus for what they're going to do about this situation. So we need to go on to think about the stage 2 of the process, where we meet with the landlady. Got to gain her trust because she's going second. You'll see she's a bit more guarded, I suppose, because she knows she's going second, and getting the trust with party 2 is often a little bit more of a challenge. Exercising our impartiality, as I say, and maintaining the privacy of it. So we're not passing on to party 2 what we've heard from party 1. Whatever they want to raise and discuss between themselves, they can bring those topics up when they get together in the joint session. It's not our job to convey those things from the first to the second party. So let's see what happens when we get together with Helen in stage 2 of our process. So I'll put that away, Helen, and say, just please start anywhere and tell me about what goes on with you and Molly.
So I've been renting to her for about a year, her and her 2 children. Everything started off fine. She was working, was always fine with the rent and everything. It just feels recently, maybe since, I don't know, she got made redundant a few months ago, just feels like she's getting a bit out of control. Maybe her lifestyle. I've heard things from the neighbours that maybe she's not the sort of tenant that I would have taken on in the first place. You know, had I known this was going to happen, this was the situation we were going to end up in. I've heard from the neighbours that she's having loud parties. There's potential. I've said she can smoke in the garden. I've got evidence that she's been smoking in the house as well, which it specifically says in the contract that she's not allowed to. I've heard from the neighbours there's potential smoking of cannabis in the garden, which obviously is a concern. She's having lots of people coming and going all the time. There's lots of noise. She just makes lots of claims about things which she's saying are faulty in the house, which I'm not completely in agreement with. The one problem she keeps going on about is the boiler. I sent someone to fix the boiler, and I had a set time. I told her when the engineer was coming. She wasn't there, you know, and she claims it's a really big deal. But you know, if it was that big a deal, she'd have stayed in when the engineer was coming. So I don't know. Anyway, now it's come to a bit of a head because she's now refusing to pay the rent at all, and I just, you know, feel like it's make or break, really. You know, I don't particularly want to have to get new tenants in again. So I kind of guess I would like to get it sorted. But, you know, bottom line is, you know, this is how I make my living. It's my house. She's breaking her side of the contract, not following the rules that were clearly laid out in the contract that she signed at the start. You know, and it needs to get sorted. I need her to start paying the rent again, or, you know, I'm going to evict her, is the bottom line. So, yeah, it needs sorting.
The truncated version of what would have been a session of an hour and a quarter or so with Helen, and we would have had similar sort of time with Molly as well in the first instance. And what you notice is how they've become very positional. So from Helen's point of view, it's my house. From Molly's point of view, she's got to meet the terms of the agreement. So they're very much, here is my insistence about what's got to happen, and the other party, here's my insistence about what's got to happen. And in the sort of litigious process, if this was going to court or to a tribunal, there would be an intention to see what the people's legal rights are, trying to instantiate those rights. Whereas with mediators, we're trying to keep it rather more pre-formal, without prejudice to any formal process, and making sure that actually we reach an outcome that satisfies both parties' interests, whether or not it means that they meet their full instantiation of their legal rights. But it's about what they want to do. Just wanted to sort of put that point in there as we head into stage 3, which is about preparing for a joint session. So stage 3 is very much about getting ready to work on the dispute. We think about, in terms of the way forward, is it appropriate to bring them together? Is mediation the right remedy? And thinking about all the prep for a joint meeting. There's a few tests that we have to do, and the reason I mention about the legal rights and wrongs is if there was something quite significantly going wrong, if the children were at risk because of the state of the property, if the allegations were of a criminal nature, if there'd clearly been some serious misconduct between the parties which reached the threshold of something that would need to be investigated in more of a legalistic way, then I'd be a bit nervous about going into mediation, because bottom line for mediators is we've got to make sure we're not putting anybody at risk. So 3 is about deciding how to take it forwards and whether we should bring them together. In this case, I'd have no hesitation about bringing them together. Sometimes if the temperature is rather higher and if there's any risk that it might turn into something rather aggressive, certainly if there was going to be any threat of any physical aggression, then we wouldn't be bringing them together. But assuming that that's not the case, we would then look at our stage 4. Stage 4 is all about the joint meeting. It's about getting the parties in the same room together. You'll see a little bit then of some stage parts of the stage 4. We haven't got time to go into too much detail, but the introductions, establishing some rules. We only need a couple of rules, giving the parties some uninterrupted time to speak, summarising what they bring, and deciding on an agenda of issues that need to be negotiated. So this is one of the most important things, is agreeing what needs to be agreed. We can't talk about things that are outside the scope of mediation. No point arguing about things that neither of these two parties have, that they're not empowered to solve. So we can only talk about the things they're empowered to solve, which are what we would call mediable. And we get to the point of an agenda which should be just mediable issues after we've given them a chance to have some uninterrupted time and each lay out their stall from their individual points of view. So we're going to look at that now in a little bit of the stage 4. Like I say, we only see a snippet, a snapshot of certain bits of it. At this point, we're hearing from Helen. She's about to have her bit of uninterrupted time. Okay. Which of you would like to go first?
I don't mind going first.
You can go first.
Thank you. So for you, Helen, to make your comments to me really about what's on your mind as you arrived this afternoon and what you'd like to get out of this.
I would like Molly to pay her rent as she's supposed to do. I would like Molly to start acting like a grown-up and not using the house for parties or anything it shouldn't be used for. I'd like her to keep to her side of the tenancy agreement by not smoking indoors, not doing her laundry indoors, and just take a bit more responsibility for, for her actions and how she behaves in the house. In things like, we had an agreement that the engineer would come out. We agreed that she'd be there. She wasn't there. It's just.
I'll just pause you a second, Helen. So Molly, I asked you to please allow Helen to have a bit of uninterrupted time. Okay. You made a sort of a snort and then you just started to interrupt there. So I'll let the first one go, but please let Helen finish. And when it's your turn, I'll make sure the same thing happens in your favour as well. Mm-hmm. Okay, thanks. So from your point of view, Helen, you want Molly to, from the way you put it just there, to adhere to the terms of the contract. Yep. Especially, around some of the issues to do with the engineer, to do with laundry in the house, to do with conduct around the house. Yeah. And essentially to stick to the terms that you're saying were agreed at the time the contract was signed.
Absolutely. And to pay the rent.
And in particular, you're looking at getting the rent paid. Mm-hmm. So that's Helen laying out her stall, telling us about things from her point of view, and we would get both of the parties to do that individually, making sure they're not interrupted by the other one. The mediator is trying to keep order, give them 2 or 3 minutes to have that bit of uninterrupted time at the start of stage 4. The mediator's job is to think about, okay, let's reframe this. Let's think about what is it that needs to be negotiated, and thinking with the end in mind. Where do we need to get to? We need a solution around the rent payments. We need to figure out something to do with the hot water. We need to think about how better they can communicate if things do go wrong. So the mediator's job is not to interrogate or investigate the historical things that the parties bring, but rather to think about the future of an agreement that would solve these things. So what can they do differently starting tomorrow so that all of these issues of conflict go away? And again, back to this positional thing. You've got to do this. No, you've got to do that. Well, you have to do this. You must do that. We're getting away from that and thinking about what are the underlying needs and interests. And we're also thinking about not who's right and who's wrong, but thinking about the shared responsibility for the two parties to make this situation better, putting their heads together and collaborating rather than banging their heads together to try and prove who's right and who's wrong. So we moved that forwards by getting an agenda between the two parties in the joint meeting. And let's have a little look at that part of the stage 4, which is all about setting the agenda. So we can start to get a few things written up on the flip chart. We can have an agenda. Would it be okay if I call it an agenda?
Yeah.
Happy with that? Great. So let's go there. So let's think about, I want to be guided by you on this very much. Think about what you would like topics to go on the agenda, the important things that need to be discussed. Where should we start?
Smoking in the house.
What do you say about that, Emily?
It needs to be discussed. So,
The noise, the amount of people coming and going all the
what
time.
amount of people?
I'm happy for the two of you to speak together now if you want
So,
to, as long as you don't interrupt.
Well, I told you Simon said there were people coming and going all the time, so yeah, that's, I think, counts as
So
conduct.
Simon's saying this as a member of those groups.
I think you've forgotten-
And the groups of 3-4 people who come round so infrequently, it's barely worth mentioning.
Well, it's worth mentioning to Simon,
Okay,
Molly, before you moved into the house, Simon was there already. I've had a relationship with Simon for a lot longer than you, and if he tells me there's people coming and going all hours and that there's too much noise, then I believe him.
Okay, fine. But if you want to discuss it, then we can put it on the agenda.
Conduct around the house.
And the garden.
What do you say about conduct around the house, Molly?
Well, I want to discuss it, so yeah.
Yeah. Okay. You're right if I call it that? You two?
Yep.
Yep.
Great. Of the mediation process is getting the agenda clear. Quite often when people are in conflict, it feels like everything is contentious, everything is disagreed and nothing is agreed. So we've got to whittle it down a little bit. Quite often we have to eliminate certain points of contention because they are simply not subject to mediation. They're things that can't be negotiated and agreed within this particular setting. But we'll usually come up with, as we have in this case, 3 or 4 things that can be sorted out, that can be negotiated between the two parties. So the next thing really is think about, okay, where do we start as we move into stage 5 and start to look at the negotiation phase? So we're thinking about picking an issue to begin with, this reframing thing, which is what I mentioned previously. It's moving from the past to the future, getting away from people's positional insistencies and into their interests, and getting to the place of a shared responsibility to try and make the situation better, rather than just having this standoff where each of them insists that it's the other one's fault. Sometimes we have to speak to the parties separately, either if things get heated or if they persistently break the rules or if they fail to mention something really important which they've said to the mediator in private, which they then don't bring up in the joint session. So there's a few reasons why we might have joint meetings and that we'd speak to the parties separately. But otherwise what we're doing is getting the negotiation going. We're sort of working on the issues in the stage 5, using this reframing thing and trying to arrive at areas of consensus where they have come up with a third way usually. It's not what the one says, not what the other one says, it's what arises when they put their heads together and come up with a third way, a new idea about how they're going to do things so that their conflict reduces and so that starting tomorrow they have less contention and less of a dispute. Let's see how that looks. Again, a tiny snippet of the stage 5 working on the issues. So what do the two of you want to talk about next?
Conduct around the house.
Let's go there then. You all right with that, Molly? Mm-hmm. Right, what should we say about that? What have the two of you got to say to each other about that? I'd rather see the conversation go this way now, if possible.
I think that you are not behaving in a manner that I would expect of one of my tenants, and I think that you're not treating the house as respectfully as I would like you to.
And what gives you that impression?
Reports that I've heard from other people and the evidence
So second-hand information?
Second-hand information, but from Simon next door, who, as you know, I've known for years. He's rented off me for years and I trust him. And from the evidence that I've seen for myself when I've come into the property and seen mess everywhere, ashtrays inside with potentially
that's
with
that needs to be
illegal butts in the ashtray.
Okay, well, I'm going to address that because the way that you went around gathering that information was completely wrong. You did not act as a landlord. You were snooping around my house without my permission. I was not there, and you knew that because you have such close relationship with Simon. I'm sure he let you know when I wasn't in the house.
No, I trust him.
But anyway. So you went in the house, you're going on about illegal activity. We've already said we're not going to discuss that, so rule that out. The ashtray, you had to go into my room and find that. That would not have been left out. That would have been in a drawer. It was left out. It wasn't. That would have been in a drawer.
It was left out.
Let me pause you a second. I think it's fair to say that you're not going to agree about a couple of things. One is what has been going on in the house, and the second is about how the information should be gleaned about activity in and around the house. So I think you need a better deal, better understanding about what's okay in the house and what isn't, and you need a better understanding and an agreement about, if you are going to be in receipt of information, Helen, about what's going on around here, how you get that information or who you get it from. That seems to be particularly upsetting to Molly, that you've been in the house in her absence, and also upsetting to you, Molly, that the accounts of your conduct have come from a neighbour who's clearly got a prior sort of relationship with Helen.
Well, I just, on you coming into the house, I just feel completely violated by that. Because I didn't know that you were coming in. I didn't know that you had been in when I came back.
You want to know when Helen's going to be
I
here?
want to know when you're there. And legally, you should have given me 24 hours notice.
Legally, yes, I should have given you 24 hours notice.
Yeah.
I know I shouldn't have come in, but it was extreme circumstances. Because at the time, you hadn't paid the rent. And I'm hearing reports of things going on that shouldn't be going on. So I've got concerns about my property.
So you want to feel reassured, Helen, of how the property is being used?
Yeah, definitely. What it's being used for, how it's being used.
And what conduct and activity is going on in here. Okay.
And potentially, as far as I know, the actual safety of the house itself.
The house is completely safe,
so
as long as you perform.
Let's say there's two things here, and
maintenance.
it kind of ties together your two agenda items here. One is about conduct around the house, and one is about how you get to hear about conduct around the house, Helen. So you need a deal about what's okay in terms of behaviours and conduct around the house. Let's talk about that first. Try and keep this bit out of it for now. Try and keep that separate.
I would like you to ensure that you don't smoke inside the property from now on, please.
Do the two of you know what's in the tenancy agreement about that? I'm not going to get your tenancy agreement out. I don't need to know what's in it, but do you
I was pretty sure that in the tenancy agreement it was stated that smoking's allowed in the house.
In the garden.
In the garden.
In the garden, not in the house. So I want you to make sure that smoking does not happen in the house by you or any of your friends.
So are you agreeing to that, Molly?
If that's what's in the agreement, then I will agree to it, yeah. I've signed off on that, so I agree.
So the mediator's job in that phase, which I hope you got a tiny flavour of, it's a very short clip there, but is to try and see that the two parties have got equal negotiating power. It's to try and sort of cut through the woods so you can see the trees of what it is that both parties want. What is their driver, their imperative, their needs, their interests, and get the negotiation going around that so we can draw out some areas of consensus. Sometimes having to address interruptions or people talking over each other, or sometimes what happens is they get in each other's space, or there might be a bit of low-level name calling or stuff that's really not constructive. So the mediator's got to try and address that equally with the two parties, keep the general momentum going forwards, keep them stuck on their agenda. Got to make sure we're working off the agenda and not getting distracted the whole time, so that we approach the point where they're actually putting together some kind of an agreement. And this is where we wanted to head, of course. So the output from stage 5 should be some draft points of agreement, which take us into stage 6, where we start to write these things up. So we could use a flip chart, we can use any kind of medium, just to get some sort of, shared record of what it is they're going to be agreeing. I like a visual, so if we do have a flip chart or whiteboard, it's good to use that so the parties can see this agreement starting to be built up, and it's their output. It's not down to the mediator to tell them what they're going to agree. So it's good to see the work in progress, as it were, as we move into our stage 6. So we're putting an agreement together, we're deciding who's going to see an agreement. In this case, there's no need, I don't think, for many people to see it. Sometimes housing provider might want the neighbourhood officer to see it, neighbourhood manager. If it's a multiple occupancy, then perhaps the house manager or whoever it is. But generally speaking, the agreement is arrived at by the parties. They decide the terms of the agreement. They decide who gets to see it. What we like to do is to have a fallback arrangement. So something that they agree they're going to do should the agreement break down. It doesn't usually, as it happens, but just in case the wheel comes off, what is it you're going to do so that you don't end up back where you started? And should the agreement not be comprehensive, or should we not reach an agreement, we need to think about any alternative courses of action as well. So in the case of Helen and Molly, as we do in round about 80 to 85% of cases, we do manage to reach an agreement, a good agreement that they've arrived at, which addresses directly the points on the agenda, which is consensual. They've come up with it themselves. They choose to keep it confidential if they want to. And with that agreement, we then think about moving into our stage 7. This is where we close the session down. We talk about follow-up. What we like to do is to follow up these situations in about 6 weeks to see whether the agreement's worked or whether it's come off the rails. So we'll do that discreetly by email or text, or if it's in a different setting, it might be using a different medium, but in some way or other privately to get in touch with each of the two parties and just to check that the agreement is still working. We close the session down, have a quick chat about that follow-up period, and then we're more or less at the end of our mediation. So let's just have a look at that then with stage 7 and following up. Like I say, it's a good faith agreement. It's based on you two trusting that you're going to do one another, that you're both going to do what it says on the agreement. If things don't work out between you, in the unlikely event that things don't work out between you, it might be a good idea if you speak to each other directly first. But of course, I'm available again if you need to come back to the Community Mediation Service. Yeah. And do that. So we'll have that as just a fallback clause, basically. Talk to each other and come back to Community Mediation Service if you need to. All right.
Yes, thank you.
Thank you very much.
So you're happy to finish there then? So
yeah.
I think you've reached a very good agreement. Well done. Thanks for putting your efforts into that today and for making that work, having a good conversation, and the best of luck for the future, and I hope it works out between you.
Thank you.
Thank you.
Thank you for
you're
your help.
welcome. You're very welcome. So there we can see getting to the end of the mediation where we're talking about following up. So it's good for the parties to go away on the day with their agreement and to have a discussion about a period of following up after usually about 6 weeks, discreetly by email or text, depending on the setting, just to check that the agreement's working and there's no need for any further support. So as I've said before, around about 4 out of 5 cases we'll get to a good place where they will reach an agreement and there's no need for any further action. In some cases that doesn't happen, of course, but you can't win them all. So there we are in the stage 7 where there's a follow-up period appropriate, close the session down, and also with the parties' consent deciding on who's going to see the agreement. So we've got to make sure it's down to them as to whether the agreement gets seen by anybody else. It is sometimes appropriate that a neighbourhood manager sees it, or depending on where the referral has come from, that another party may see their agreement. But the parties involved, Helen and Molly in this case, they come up with the words of the agreement, they decide what gets agreed, they decide who gets to see the agreement, and then we would follow up with them after a few weeks, like I say. So there's the 7-stage model, very briefly, just with dipping into each of the stages. You can see what happens with the 2 individual meetings, a bit of thinking about whether we can bring them together and whether mediation is the right remedy, get them together in stage 4, building consensus in stage 5, reducing that to an agreement in 6, and then closing it down and following up in stage 7 and agreeing about following up with parties after a few weeks. That really is the 7-stage model. Like I say, it's a model that can be applied in lots and lots of different settings where there's any interpersonal dispute. It would be a bit different if it was a commercial dispute, and we have a different model for that, which we're not going into today. So I hope that's been useful, and especially useful to see it all in action with the dramatised dispute and the conflict between Helen and Molly there, as we've seen today. If you'd like to see any of our other webinars, and indeed if you want to watch that again, go to our website and you'll find an archive of webinars, today's one as well. And in terms of what we've got coming up to be added to that library, next one round the corner is in June, Friday 24th. looking at mediation crossing continents. So how can mediation be successfully applied in disputes across countries and continents? And just in connection with that, with Brexit and with our need to remain in touch with our EU customers, in spite of sailing off into the North Sea, we have started a company in Ireland called EU Mediation. So we have a foot in the EU still. So I'll be saying a little bit more about that in June, just very briefly, and talking about mediating disputes across countries and across continents. So you've got that to look forward to, Friday 24th of June. So thanks very much for your attendance today, and look forward to seeing you again in future. In the meantime, do keep in touch, various ways of doing so, and you're very welcome to like and subscribe our YouTube, follow us on Twitter, check out our LinkedIn and our Facebook as well. Some useful material on there, some helpful stuff, free resources, and very pleased to be sharing our expertise, sharing our insights into the world of mediation with you, talking about tenancy today, many other topics to come, many on our archive, which I do hope you enjoy. Thanks for today. Look forward to seeing you again.